there is the certificate mentions diploma of fellowship, such and such. Let he use this. You will be given permission to conduct the proceeding in terms of the act. Give him the reasons that these are the reasons. Thereafter, whatever is the order, provision for appeal is there.
But may I not only react to this
Yes, please.
in this very humble way?
Yes, please.
But the reason that I'll give is in the charge sheet itself. And
maybe there in the charge sheet, not reflected in the order sheet.
Can you consider this, Milord? He is aware of the charge.
Maybe.
But he doesn't deny.
Please, no.
I tried to find out. I tried to find out from the petition.
Yes.
That he has said.
He may know a lot of things. Why will it not go down in the order? It is only for this reason.
Milord, the reasons may or may not be there, Milord.
And thing is,
yes,
he is using this for 6 years. You conclude the proceeding in accordance with law at the earliest. And he is during the period that you will conclude the proceeding, he will use whatever is there in the certificate.
But that will not do away with the wrong that he has done.
Maybe, yes. But then you say he is using this as a qualification without registration.
I'm not saying.
Oh, whatever. Now, whether please come. And what about the communication? You did not communicate the order to him.
As per the rules, Milord, it has to be gazetted. The gazette notification has been done.
All right. And no,
he has
no, he has not. No communication.
Fine. Caveat page, fine. But my instructions are that it has been dispatched.
Maybe he'll receive it. Yes. But then this has come prior to that. Please come.
But is your lordship's pleasure to dispose it of?
Absolutely. I'll give you the liberty to proceed.
Give me a moment to take instruction.
From whom? No, you are the all in all. No taking instruction and no consultation. I give you liberty.
No, the instruction which I would require is from which stage should I start?
What I would propose, you have given the charge sheet and a reply is there. Start it thereafter. Give him a hearing, or if the hearing is there, hearing is over.
Yes.
Hearing stage is over.
I think the hearing on the 3rd of July, they gave me questions. Now the questions and the answers are appended here. No consideration thereof.
No, they'll consider in the final order. If the hearing is over, then you can
give me an opportunity of hearing to explain myself.
Further opportunity.
Yes, another opportunity. Because my specific stand is this is not a degree. Whatever stand might have been taken, in the last representation, I have taken this specific stand.
In all along, in your communication, you have mentioned
also that in the initial stages of the reply, even against 9th June, the language is little different. But starting from page 67, 66, kindly sees the response.
Thereafter, the legal advice came in a different manner.
I don't think there was any legal advice.
Previously may not have been, but thereafter something has.
He has deposed before the authority.
Yes.
Committee.
Whatever is there.
There, at page 75 of the petition.
Written communication.
Please come.
Written questions.
Written communication. Whatever. Yes.
The petitioner has averred in the writ petition that he is a medical practitioner and he holds the degree of MBBS and DMRD and has been honored FRCP within bracket Glasgow and FIAMS. Stop. He claims that he is the secretary of the Indian Medical Association and the member of the MAC, National Medical Commission. Stop. He is aggrieved by the order dated 4th July 2025 passed by the West Bengal Medical Council, whereby he have been found guilty of infamous conduct in a professional respect. Now, conduct in his profession, and decision has been taken by the council to remove him from the register of registered medical practitioners maintained by the West Bengal Medical Council for a period of 2 years from the date of communication of the order. Stop. The learned advocate representing the petitioner submits upon instruction that the impugned order is yet to be communicated to the petitioner. Stop. The petitioner got to learn about the order from the official website of the Medical Council. Stop. Paragraph. The very first point of attack is that the impugned order is a non-speaking one. Stop. No grounds and or reasons have been mentioned by the authority for removing his name from the register of medical practitioners. Paragraph. It has been submitted that a show cause was given to the petitioner on 9th June 2025, which the petitioner responded on 23rd June 2025 and responded on appeal by filing a detailed answer. Stop. In the impugned order, none of the explanation given by the petitioner has been taken into consideration. Stop. Next. The the nomenclature in the letterhead of the petitioner, which gives rise to the instant proceeding, mentions that the Royal College of Physicians and Surgeons of Glasgow offered the Diploma of Fellowship within bracket FRCP within bracket GLASG bracket close. Now offers হবে না certifies. কি বললাম? Royal College of Physicians. হ্যাঁ। To the petitioner for having acquired distinction as a physician on the 22nd day of February 2019, duly admitted a physician fellow of the Royal College of Physicians and Surgeons of Glasgow. Stop. According to the petitioner, the said diploma is merely an honor and not a regular educational qualification which the petitioner obtained. Stop. Next. It has been submitted that the petitioner is practicing on the basis of the qualification which he acquired after his regular studies. Stop. Next. On a perusal of the show cause notice, it appears that on a perusal, the show cause notice mentions that information and evidence have been laid before the council on the basis of a complaint and further inquiry on which charges have been framed against the petitioner. Stop. The petitioner alleges that neither any information, nor evidence, nor complaint, nor report of inquiry was ever furnished to the petitioner. Stop. Paragraph. It has been submitted that without the complaint or the information or the evidence or any further document relied upon by the authority to pass the impugned order has not been communicated to the petitioner. Stop. Without the details of the complaint or allegation relying upon which the impugned order has been passed, the petitioner is not in a position to defend himself properly. Paragraph. Prayer has been made to set aside the impugned order. Stop. The Learned Advocate General represents the West Bengal Medical Council. Stop. It has been submitted that the charge sheet is a detailed one and the petitioner is aware of all the charges leveled against him. Stop. It has been submitted that it is the admitted case of the petitioner that the that the diploma is a qualification for which the petitioner applied for registration of the same. Stop. Next. The communications made by the petitioner in response to the show cause notice.
One thing it needs to be shown. I have said that it has been verified. That document I have craved for kindly, it is also there.
What thing?
It has been verified by the council.
Which document? Page 30? Page 50?
That page 30 is 30. Something which is genuine, or it has been verified by the council upon my making the application.
No, how does it matter?
If wants to.
Because that is not the allegation. Yes. Is it say no?
It does not say.
I didn't see that it mentions fake or it is
no,
not.
It is not a fake.
Also mentions the said diploma as a qualification. Stop. It has been submitted that the general public may be misguided and misdirected by observing the by observing the description of the doctor as reflected in the letterhead. Stop. It has been argued that the petitioner will in no manner be prejudiced if the reasons are not disclosed in the impugned order. Stop. Next. I have heard the submission made on behalf of both the parties. Stop. The submission of the Learned Advocate General that the petitioner will not be prejudiced cannot be accepted by the court. Stop. The delinquent is certainly entitled to know the reasons for which he is being removed from the list of register of the medical practitioners. Stop. The subject qualification the qualification, the subject, the mention of the diploma is appearing in the letterhead of the petitioner for the last 6 years. That is from the date of its issue in the year 2019 till the show cause notice is issued in the year 2025. Stop. If the authority intends to prosecute the petitioner, then proper reasons ought to be mentioned in the impugned order so that the petitioner may challenge the same before the appellate authority. Stop. The impugned order discloses the appellate authority but does not disclose the grounds on which the petitioner may move the appellate forum. Stop. Paragraph. Without entering into any further details, the court is of the opinion that the impugned order is bereft of the grounds on which it has been passed, can be treated to be a non-speaking and a cryptic order and is liable to be set aside. Stop. The impugned order is accordingly set aside. Stop. The petitioner, however, is restrained from using the expression FRCP within bracket GLASG in his letterhead. Until further orders, stop. It will be open for the petitioner to use the expression
Diploma of Fellowship, FRCP.
as mentioned in the subject certificate.
Yes.
That is Diploma of Fellowship, FRCP within bracket GLASG.
Yes. Yes.
The medical counsel is directed to forward to the petitioner any information, evidence, the complaint or inquiry report based on which the show cause notice and the impugned order dated 4th July 2025 has been passed, and give an opportunity to the petitioner to respond to the same. Stop.
Yes.
An opportunity of hearing shall be provided to the petitioner. Stop. A reasoned order shall be passed by the authority at the earliest. Writ petition stands disposed.
We have also questioned the charge sheet. Kindly keeps that question open for kindly keeps that question open. But otherwise, I'll be an order to rule 2 bar.
Where?
It is under.
It will be open for the petitioner to raise all issues at the time of defending the charges leveled against him. Yes, Mr. Sen?
That was the first one.
I will record that also. I will record that also. At a paragraph, submission record korben. It has been submitted that the charges.
One is page 50.
That the communication made to the petitioner dated 15th of May 2025 clearly records that the proceeding in question is a suo motu one. Stop. Paragraph. The aforesaid contention of the authority appears to be contrary to the charge sheet which has been issued on 9th June 2025, which clearly mentions about information, evidence, complaint and inquiry. Stop. If the proceeding is a suo motu one, then the question of any information, evidence, complaint or inquiry from outside would not have been mentioned in the charge sheet. Stop. Had it been a suo motu proceeding, then the basis of the suo motu proceeding should also have been disclosed to the petitioner for him to defend his stand.
Great.
But then, do we start the proceedings from the beginning?
No.
Because then this issue will again come.
No, you provide the information and the evidences and everything, so your suo motu proceeding gets cured. Everything is mentioned in the charge sheet.
The charge sheet should go and then.
No. I won't go to that extent. I won't go because your charge sheet has got mention about the information. Why don't you pass on the information if there is any? And if you feel, I can give you this liberty also. If you feel that there is a requirement of initiating proceeding de novo, you can do so. I can record that also.
In the event it is okay.
Achha. If the authority is of the opinion that there is a requirement of initiating the entire proceeding afresh, the authority may do so. Stop. The authority shall take all steps strictly in accordance with the act and by conforming to the principles of natural justice. ওপরে যেখানে বলেছিলাম না যে cryptic order bereft of reasons, সেখানে আরো উপরে বলেছে, সেখানে এক জায়গায় লিখে দেবেন violation of principle of natural justice.
Supplementary has been taken on record.
Supplementary affidavit filed in court today be taken on record. Copy of the same handed over to the learned advocates representing the respondents. Any further thing which you would like to start afresh, de novo, in the event you feel so?